Right. Good afternoon, everybody. Welcome. Welcome to the Home Care Association of Louisiana webinar series hosted by Liles Parker. My name is Liz Gallagher, and I'm a paralegal here at Liles Parker. So today's webinar is entitled Risks Facing Your Home Health or Hospice Agency. If you hire someone on the OIG Exclusion List or the CMS Preclusion List. Today's webinar is presented by Robert Liles, Managing Partner of Liles Parker, and Paul Weidenfeld, CEO of Exclusion Screening. I'm going to let them introduce themselves, but before we get started, I just want to let everyone listening know if you do have any questions during this presentation, you can send a question through our messenger system, and we will try to address as many as possible at the end. So without further ado, I will hand it over to our presenters.
Thank you, Liz. Liz, if we can go to the first slide, that'd be great. My name is Robert Liles, and I'm the managing partner here at Liles Parker. And I'm very fortunate today to be here with my friend and colleague, Paul Weidenfeld. And Paul Weidenfeld and I have known each other for, gosh, more years than we want to admit. We first worked together when we were both federal prosecutors. Paul was a prosecutor at the U.S. Attorney's Office in New Orleans, and I was a prosecutor at the U.S. Attorney's Office in Houston. And we both have migrated to D.C. We were both detailed at one point to Washington to a managerial position as the national coordinator for healthcare fraud. So we're two of the only individuals in the country that have occupied that position. There have been several others since us, but we were two of the first. I was the first, and Paul was shortly after me. One of the reasons why I'm so happy to have Paul with me today, and I'm fixing to introduce Paul to you, is because in my personal opinion, Paul is the most knowledgeable person in the country when it comes to Medicare exclusion actions. And these are very interesting actions, very complicated, and in my opinion, it's probably the least understood or appreciated compliance risk out there, especially when it comes to home health and hospice because of the nature of your workforce and the turnover and the rest of it. So I'm very happy to have Paul join us here today. Paul is the CEO of Exclusion Screening, exclusionscreening.com, and he's going to kind of walk us through a lot of the nuances of exclusions and the preclusion rule that other folks and insights other folks just don't have. Hello, Paul. Thanks for being here. I know Paul is currently in D.C. and I'm down in Texas today.
Hello, Robert. Hello, everybody from Louisiana. As you know, I lived in New Orleans you may not know, but I was an AUSA in New Orleans for a number of years and lived in New Orleans for close to 30 years. So I'm kind of missing the state of Louisiana, and so I'm always at least happy to talk to folk who are from there. And if you ever have any questions now or later on, always feel free to give me a call. I'm sure my information is up there. If nothing else, or you can chat about the weather or, who knows what, maybe even some exclusion or healthcare business. Why don't we go on, Robert?
There you go. All right, so Paul, this question, what is an exclusion? I mean, people think they know what an exclusion is. They get convicted of something and therefore they're kicked out of Medicare. But really, what is an exclusion?
So an exclusion is at the end, it's an administrative action. It's imposed by the Office of Inspector General, and it bars all participation in any federal health care benefit program, which includes Medicare, Medicaid, CHIPS, TRICARE, FEHBP, and it will probably result in it does impact Medicaid, since Medicaid is considered a federal health care program in this sense, but it will also probably result in a separate termination from the Louisiana Medicaid program, and terminations on the list could have other implications for your ability to do business with the state. So it'll have an extended action. It really is, it's a final action that once they are imposed, there's really no appeal for them. And even when they start the process, there's very little appeal for them. We'll talk about that a bunch later.
Okay. All right. And when you say final administrative action, I mean, one of the things that you mean there also is, you know, once an exclusion action is proposed, you may have the ability to respond to the proposal. But the fact is, you can't go back and try to relitigate the underlying action that gave rise to the exclusion. Is that correct?
That's right. We're going to, and the slide later on, we talk about what percentages of the type of exclusions are imposed. But the bottom line is, if once you start adding up all of the exclusions based on disciplinary actions, those are permissive, but when you add those to the exclusions imposed based on convictions, misdemeanor or felony, then you get to about 98% of all exclusions. And you cannot, as you say, Robert, you can't contest, oh, well, I thought it was a deal, I thought it was a promise. We'll talk about that later. Once they seek to exclude you based on one of those issues, a conviction or a disciplinary action, it's going to happen. You can't fight the actual exclusion. You may be able to contest how long the exclusion will extend. And remember, states have their own parallel exclusion remedy. I think in Louisiana they refer to it as terminations as opposed to exclusions. But the result is the same. And once you're excluded from Medicare or you're on the OIG's list, you are automatically excluded from Medicaid.
Okay, and that's serious. Okay, next slide. All right. So in terms of the history of exclusions, you know, one of the things that we deal with all the time, I actually got a call just yesterday, in fact, on an excluded individual matter. I'm having to represent the client with the OIG to kind of deal with the fallout from the improper employment of someone who is excluded. But you know, while this client may not have been aware of all of the exclusion rules and the rest of it, because it is kind of obscure, the fact is it's been around a long time. They first passed this rule in 1977, so this is nothing new. And at that time, they said that doctors convicted of certain crimes have to be kicked out of Medicare, essentially. Okay. Then they added, in 81, they added the CMP rule, saying essentially if in fact you are excluded, it's possible for them to also try to impose civil monetary penalties. There were further expansions in 87, where they kind of separated out mandatory exclusions, which they had before for criminal conduct, and then permissive exclusions that Paul's going to talk about in just a second. This went on for a while. There have been a number of fairly, you know, Paul and I consider them recent, but developments in this area. In 1999, OIG first issued a special advisory opinion or bulletin where they really kind of explained this is how OIG views the impact of an exclusion, and this is how we view the obligations of healthcare providers in terms of making sure that you do not hire nor do you continue to employ anyone who has been excluded. Okay, in 2021, 4 years ago, which in healthcare is almost an eternity, but it's not really that long ago. The OIG issued a new self-disclosure protocol on what do you do if you find out that someone is excluded that is working for you. What do you do? How can you do a self-disclosure, minimize the damages to your organization? So historically, this is something that there is a long history to it. And it continues to change. Every year, there's a little twist that they'll throw out there. Next slide. Now, exclusions really kind of come in two flavors, if you will. There's mandatory exclusions, and as we're going to discuss, permissive exclusions. Paul, you want to talk a little bit about the mandatory exclusions?
Sure. So as you can see, everybody can see from the slide, mandatory exclusions are based on convictions. And if you'll notice that A1 and A2 say a conviction, any conviction, they don't limit it to felonies at all. And so any conviction, misdemeanor or felony, related to the delivery of an item or service to federal healthcare program, those account for about 60% of all of the mandatory exclusions. And what's important to know is the regulations that govern exclusions consider a conviction any resolution that results in an admission, so that a nolo contendere plea. Now, everybody thinks that the nolo contendere plea is I'm not admitting anything. Well, you may not be, but it's considered a conviction under exclusion rules, as is a lot of people, there in state law in particular, federal law not so much, but in state law in particular, there are a lot of devices to minimize the impact of a first offense. And so they'll have like a nolo pleas, or they'll have things where you can avoid an expungement, for instance, or a deferred prosecution. And so if you go for a year or two without any problem, then they will eliminate the criminal act, and so your record is clean and you have no felony. That's true for everything, but not healthcare. All of those actions, expungements, deferred adjudications, they all can, if you at one point admit to a conviction and then you later gets pulled back, they all count in terms of healthcare. So Robert and I have seen countless people say, well, my lawyer told me that they would expunge this felony and I would be clean. And it was true for all purposes, but not in healthcare. Those things all count as convictions. Now, that's any kind of conviction, misdemeanor or otherwise. There are also felony convictions related to healthcare fraud, which is really kind of, other than Medicare and Medicaid. So that would be like a provider, a private payer. And then the manufacture of certain drugs. What I find interesting about this is that A2, which is for an abuse or neglect, and it's any kind of conviction. Now, I think that the people in this, certainly in this audience, have seen quite a few of these, not necessarily in your agencies, but around in the industry. Yet they only account for a small fraction of the exclusions, which I find amazing, because these are mandatory in the sense that it says they shall, but they can only actually do something if they are in fact advised of it. So what that tells me is I know that there are lots of convictions, they don't even have to be felonies, they can be misdemeanors related to fraud and to the neglect of patients. But apparently those don't get necessarily reported, because they only account for like 19% of the mandatory exclusions, and that's like less than 10% or 8% of all exclusions. But that's what we got on the mandatories. Once they know about it, then they take the position they have to. It is mandated. Now, if they don't know about it, if it isn't reported to the OIG by the state, or if it isn't reported to the OIG by the U.S. Attorney's Office, and those typically are, then it may not happen. But once they have a hold of it, it will happen. Okay.
All right. And when they say mandatory, they mean mandatory, don't they, Paul? I mean, if you have a conviction, because all four of these are relate to a type of conviction. If you have a conviction, OIG does not have the discretion whether or not to exclude you or not. Is that correct?
Once it's in their hands, the only question is that they don't know about it. But once it's in their hands, they are mandated to exclude you. And by the way, for those ones that are saying related to the delivery of healthcare services, that is extremely, extremely broadly construed. So that if, for instance, it doesn't relate necessarily to what you plead to, they'll look at the underlying offense. So if you were in healthcare, for instance, and you and you abused and you did something that you stole something, or it was a minor theft, but you pled to something else, the unauthorized use of a computer, they will still look underneath and say, well, that was originally related to healthcare, and they will exclude you on that basis. We've seen a number of cases.
Very interesting. Next slide. Now, we talked about the mandatory exclusions. These are the permissive exclusions. Paul, can you give an overview of these?
Sure. So, a lot of the, you tracked all of these regulations that over the years that they kept adding on and refining and going back. And many of those regulations are adding different bases for these permissive exclusions. And these are exclusions which they are, it's discretionary whether they should be imposed or will be imposed, but pretty much if they get a hand on it again, once they decide they're going forward, they will. Now, you can see I think this lists 16, and there were probably more. I think there's some like 20 at this point, 21, Robert. I've kind of lost track. But if you look at the one in red, the license revocation, suspension, or even the surrender of a license, and that's something you cannot question, right? Once it happens, then it's not subject to subject to explanation. It happened. Those account for 83% of the permissive exclusion. That is the vast majority of the permissive exclusions. Second on that list is B14, that one at the bottom, failure to pay a loan. Okay, that's the second one. And the thing again is, you'll notice that those are both things that you can't understand, that you can't question. And even the third and fourth ones are all misdemeanor pleas of some sort. The vast majority, over 97%, 98% of exclusions are based on either convictions of some sort or licensing. Again, so the minimum here, the recommended minimum is 3 years for most of them. Some have actually no minimum. If it's a license revocation, it's going to be 3 years, but there's a trick to that. If you're excluded based on a license revocation, they will not allow you back in the program until you resolve that licensing issue. And that's a tricky thing, because a lot of times you've wanted to move on. Now, and okay, I get it. I no longer want to be a hospital administrator or whatever your position might have been, but I just want to work in their IT department. Well, if it's the IT department for a hospital, you can't do that if you're excluded. So it's very tricky when you've had the licensing revocation. My only recommendation is, if you're in the course of a plea agreement and you're trying to resolve something, try and find something other than an exclude, see if you can convince the OIG to exclude you under something other than B4, because you will have to resolve that licensing issue one way or another. We've been able to do that on occasion, but it can be very tricky.
The only other thing that I would add, Paul, is even though it's called permissive exclusion, that almost suggests that there's a good chance that OIG is not going to do it. What's your opinion about that in terms of how permissive is it really?
Well, it's permissive in the sense that they can choose, but once they've chosen, once they get a hand on that license revocation, they will evaluate it. And once they send out that notice of intent to exclude based on that, or they may even just go forward with a notice to exclude based on that, once they've done that, there's no going back. There's no explaining it. Because they can, in fact, exclude you on that basis, and you can't question it. So they have some question. It might be possible before, if you're in a global situation and you're trying to resolve your case with everybody, you're trying to resolve a criminal case and a civil case, and the potential case with the Office of Inspector General, it might be permissive in that sense. You might be able to convince them otherwise, but not likely, but perhaps. Or you might be able to convince them to exclude you on some other basis so that you can get in the program. But it's not permissive in the sense that you really get to argue about the basis of it if it's based on a licensing issue and if it's based on not paying, Actually, you can resolve the not paying one, just promise to pay, but they'll exclude you.
Yep. Next slide. Okay.
So,
These are the potential CMPs. What would you say about these, Paul?
they're too much.
And they go up they go up every year.
They do, as a matter of, and so they're really kind of insane, because if for each violation, well, every violation is every time a claim is submitted based on that exclusion. If it's a billing provider, well, it's going to be, 1,000 times or 150 times a day. But even if it's a non-billing provider, if it's whatever, everything they touch is a claim, right? It's part of a bundled claim for everybody in the facility. So basically, it would be a violation of the 8th Amendment, the excessive fines and penalties, if they ever tried to impose it. So what they do is they basically create, and Robert, you have, I know, handled a bunch of these, where they create a proxy for what that civil money penalty will be, or what the overpayment is, and then they kind of avoid those civil money penalties. And how does that process work, Robert? Because you've done a number of those, I think.
Well, you're right. In most cases, if you're working with the government, with the OIG, in most instances, they will waive the penalties, but they're still required by law to go after you for the overpayment. Now, it's very difficult to calculate an overpayment. Well, all right, so let's say that I'm a home health agency, and I've got a nurse that worked for me, and somehow she slipped through. We weren't using exclusionscreening.com. She slipped through, she was excluded, and she's been working for us for 6 months. She is not even though she's a licensed professional, she is not a billing provider. She is not, we don't bill her information out on a Part B claim or anything like that. What they do is, when they find out that she's excluded, if they find out, it's a bad thing, okay, because they're going to want more from you probably. But if you are doing your own internal reviews and you find it and you do a self-report, then they're going to come in and they're going to calculate what they call a proxy damage amount. And the proxy typically is, they look at the percentage of all the money that you have come in. Let's say that I've got a home health agency. What percentage of my revenues come from federal health benefit programs? Well, most of the people on this phone call is probably upwards of 90%, if not close to right at 100%. Well, let's just say it's 90%, right? And let's just say that for the period that this lady worked for our home health agency, she was paid $40,000, which is probably too much, but let's just say $40,000. So what they would do is they would say, okay, well, we want you to pay back then as proxy damages. Take the 90%, 0.9 times the $40,000, okay? So we want $36,000 in damages. That's probably what they're going to do. I'm sorry, they're not going to call it damages. They're going to call it basically a proxy overpayment, if you will.
And so in most self-disclosures in a non-exclusion case, they will, for a self-disclosure, they'll multiply that overpayment times 1.5, whereas if they go after you, it's going to be, or the DOJ goes after you, it's going to be at least 2 or 3 times the overpayment. And so I think that don't they usually, if it's self-reported, they'll keep it at 1.5, or would they just keep it just for the?
No. Well, in the cases I've handled, I've been successful in keeping it at just 1. So they didn't go after a multiplier on us. So it is possible. It is possible to just get out of it for the what they consider to be actual overpayment with no damages.
I think that you've, as far as I remember, most of yours have been relatively have been pretty much mistakes. One way or another.
Yes. We've been able to work up a decent defense as to how we missed it.
Right. Whereas I think that if you don't have that decent defense, I think that they are going to impose the multiplier. But you've been able to explain how it happened and why it happened, and even though you explained how it happened and why it happened, you still had to pay back the overpayment, didn't you?
That's right. You can't get out of the overpayment. But you raised an important point, though. Paul, and that is that you know, there is a big difference in identifying this yourself and turning it in, and versus somebody else coming in and coming after you. But one of the things that we always had to depend, that I've been fortunate that we've been able to put in our favor in all the cases that I've handled so far, is that my clients were in fact already screening every month. It's very easy to make a mistake, okay? So even though they may have been using exclusion screening, if they gave somebody the wrong name, or if the employee gave them the wrong name, then you're not screening the right name. So it got missed. And then at some point it pops up. So,
and something that, oh, I'm sorry, Robert.
So my point though is, you need to be screening. You're still going to make mistakes. Nobody's perfect. But at least if you're screening, you've got that excuse, and that is worth a lot.
And so something else that this slide makes me think about, and that's important, is that, you know, you need to screen everybody. Now, it used to be, and I think for a large part, still a lot of people think that you just need to really screen your billing providers, and that, well, because you're credentialing them every so often with all these people, that they're clear, and so then you're done with it, and you don't really need to worry about it. But the fact of the matter is that the billing providers account for a relatively small percentage of the people on the exclusion list, and that the largest percentage are nurses or people in the nursing profession, or people, caregivers, people whose hands are on patients, and which makes sense, because the goal is to protect beneficiaries and the program. And so that a principal goal is the beneficiaries. And so, you know, we have seen very large settlements and very large penalties over in hundreds of thousands of dollars for people who are, you know, who are nurses, who are people at intake, you know, even and actually at intake is very severe, because they have access to everybody's records and they can see things. And so it's not just the billing providers that need to be screened. In fact, anybody and everybody involved in the practice. And I know we talk about that later, but keep in mind that this is not just a matter for your doctors or for your therapists or the people submitting claims under their numbers.
Yep. Next slide. That's just more. Yeah, that's just more of the same, isn't it? Oh, that's
well. These are the assessments which say I've never seen them impose. They theoretically can impose you for the cost of their investigation, but they can extract enough money in so many different ways. They very rarely use this, but that's there.
Okay, next slide. All right. So, you know, the question comes up. All right, Robert, I got the message. We're supposed to screen. Okay, what exactly am I supposed to screen? Paul, you want to we're already running out of time. Paul, you want to briefly go over these?
Sure. So the Office of Inspector General is going to post theirs every month. They update it. It's the LEIE, the list of excluded individuals and entities. That's the mother load. That's the one you absolutely have to screen. You have to make sure none of your employees, vendors, or contractors are on that list. All states, almost all states, about 44, they have their own list. Louisiana has its own list. They are, although everybody on the LEIE is supposed to be considered to be on the Louisiana list, they may or may not be. And there's going to be a lot of people on the Louisiana list that are not on the LEIE, which means that they can't participate in their Medicaid program if they're on the Louisiana list. So you've got to screen at least your list, your state list, and if you're doing business in other states, you have to screen those. The CMS has a preclusion list, which you can't access, and we're going to talk about that later. Only Part C and Part D payers can access that. There's also the GSA, the General Services Administration, Statistical, blah, 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 GSA SAM. That is a list that you are, if you take Part C, or if you're involved with Part C, Medicare Advantage, then you are probably, almost certainly, required to screen that list as well. It is a debarment list, And it's questionable as to what it means if someone who is on there because of some totally unrelated healthcare reason. But if they're on there, you are going to be required by all managed care programs to screen that list, guaranteed. And then, of course, there are other lists which you may contractually have to screen. And you really need to read your contracts with your payers on this. Private payers often add stuff. They'll add FDA. I don't know if very often if they will, home health and hospice will have to be screening terrorist lists. But goodness gracious, you never know.
You never know.
You never know.
Next slide. Next slide. All right. So, Paul, this question really goes to what does it mean to be excluded? Why is it that I can't work for someone if I have been excluded from participation?
Right. The idea of an exclusion is we're going to keep bad actors out of the system because bad actors risk the programs themselves, the public fisc, the dollars, but they also propose a risk to patients. So how do we eliminate them from the process? Well, we make any service that they provide directly or indirectly unpayable. Can't pay any system any service that they provide directly or indirectly. And that's why you have to screen not just your billing providers, but your employees, your agents, your vendors and your contractors. You also actually owners, because owners cannot be you cannot be owned by an excluded party, and if you are or have an excluded party as your director. So any payment connected by any service they provide, direct or indirect, is a violation, and those claims are improper. You can't even use, there was a case in Louisiana where an excluded party tried to go and become a biller, and they said, well, I can do that. Well, that person actually got prosecuted criminally. So you don't want to be involved in that. So there it is. It's a monetary penalty so now here are your layers. Number one layer is you can't get paid for anything. Anything you get paid is an overpayment. The second level is there's a civil money penalty potential for any claim that's provided. And the third is that it is an overpayment. And so overpayments can, as we know, can become fraudulent claims if they're not paid. So it's all about the money. That's how they keep people out.
Paul, you mentioned owners. I had a case where the owner got crossways with the government and ultimately was excluded. And we had to work with him and go through and divest him of his interest in the company. He could no longer have anything to do with the company. Couldn't have any ownership interest at all. Couldn't be an owner, but keep his mouth shut, be a silent. No. He had to be out of it. So this is very serious stuff, guys.
And 4% actually of permissive claims, that's the third largest section of permissive claims, are exclusions based upon the ownership, an excluded owner trying to control a company or maintain some level of control through a straw man or anything. So they are very interesting. A
lot of cases out there where people tried to play games with that, and they get in trouble.
Right. And they don't, and that really, when they latch on to that, they'll turn it into a False Claims Act case, among others, and a criminal case as well.
Yeah. Paul, the very last bullet there, just to touch on that, volunteers. Volunteers. What if somebody says, okay, look, I don't want to be paid. I just want to come in and help.
Right. So it's interesting, and they actually specifically address that in their 2013 guidance. And the point here is that so what kind of volunteer? Well, if you get a bundled payment, and so and the volunteer is actually providing part of the service that's required under that bundled payment, so that if it's a nursing home, for instance, and you have a bundle payment per diem, and part of that would be everything involved, putting the roof over their head and so forth. So if that excluded party comes in, they are contributing indirectly to the submission of that claim, and you can't do that. They will not. They want to keep those excluded parties away from federal beneficiaries and federal programs. It's that simple.
Okay. All right. Next slide. All right. So Paul, this is a very, I think this is fascinating. Is there a federal law that says you must screen?
No, there's not a federal law that says you must screen. There's a federal law that says I will impose penalties on you if you employ an excluded party, if you submit a claim for services prepared by an excluded party. So, you know, and it's an overpayment, and so I will subject you to a civil money penalty and an overpayment. But I'm not going to say that there's they go around the circle and make it your responsibility to know who you're employing and who you're doing business with. So that's the way they do it.
Yeah. So like with the analogy of the carrot and the stick, there is no carrot; it's all stick.
Basically, yes. That's right. The carrot supposedly is you are being compliant with, you know, and you can have a good compliance program and you're following it, but you don't get anything for it. That's right.
Okay. But now states may have a requirement. Is that correct?
Many states. I'm thinking
like
of
Texas,
Louisiana.
for instance. You know, Texas actually is part of the participation agreement and there are other regs. You must, in Texas, for instance, screen every database, every state database, and the OIG. So even though Texas mandates it, even though the feds don't.
Actually, now that I think of it now, as I remember, Louisiana also has, when you do a participation agreement with the state Medicaid program, the participation agreement will say that I certify that none of my employees, vendors, and contractors, and I believe that the one in Louisiana says, are now or have ever been. And I don't even know how you could do that.
Tell me that. Yeah, which is crazy.
Right.
So they don't even want people that have, you know, gotten out of the other side and fixed the problems.
And I don't know how you could possibly know how it have ever been if they've been, you know, if they have been reinstated on certain programs. But in any event, the participation in Louisiana specifically says that, you know, you in Texas, you actually certify. It says I certify basically under penalty of perjury. And Louisiana, your participation agreement is going to have a penalty provision as well if you don't answer all the questions honestly. So while there isn't a specific thing that comes down that has regulation X101 that says you must, you indirectly it requires it, because if you take Medicaid or any other state program dollar.
Okay. Next slide.
And also many privates will require it as well. You know, a lot of privates or Medicare, each of the Part C payers have their own. They often have every 30-day requirement. And by the way, that 30 days is magic, because what the OIG says that if you do it every 30 days, we won't impose civil money penalties. But if you don't screen every 30 days, we will hammer you, or can.
Okay. Next slide. Okay, so what is the best practice, and where does that come from?
So the best practice comes exactly from this. So every month, you screen your employees, vendors, and contractors. Now, with at least the OIG, probably the GSA if you're taking Medicare Advantage, and your state, I would recommend the best practice is to have a vendor exclusion screening or some other vendor that does all of the states. It's not that much more money if you do it that way. And it's a best practice for a couple of reasons. For one, you may have signed that participation agreement with the state. But also, if someone's been excluded, the nurse has been excluded from another state and they just haven't gotten there yet, they haven't found out about it yet, do you really want them on your, working for you? Do you really want them in? I know it's tough finding people, but do you really want them in the homes of people or handling hospice matters? I don't think so. I think that, your best practices, it's best to be safe, and if they are excluded elsewhere, there's probably a reason. You can find that out. But so that would be your best practice. But at a minimum, your state, the OIG, and the GSA every month, and for compliance purposes, and I would strongly recommend that pricing isn't that much different. I would strongly recommend that you have a vendor do all of the states. There we are.
Wonderful. Next slide. Okay, so and we've talked about how important this is, the penalties that can result if you don't do it, how broad it is. Can a home health agency do this themselves?
Well, yes and no. Theoretically, you could have someone and probably have a couple of FTE to do it on a regular basis. But the OIG's list is over about 80,000 now. The GSA is about 140,000 names on it. Louisiana alone has about 2,500 names on it. And how are you going to, how do you compare these lists? And many state lists and many lists are not even in Excel. But how would you, who's got the facility to compare names versus names and dates of birth? The fields are different. It's really almost impossible for any vendor, any individual to do it. Vendors like exclusion screening and other ones, we have screening, we screen everybody, we screen possibilities of names. We have, a screening protocol that's broad. It's just too hard to do, I think. If you have more than 3 people on it, and you're trying to go against a list with 150,000 names or 80,000 names, and their lists change, it's just too difficult, honestly. I mean, I've been in healthcare for a long time. I know what the problem is with providers. I know how providers, it's tight. The cost is very inexpensive. It's $100 a month, maybe even less, maybe a little more. I don't know, depending on your size. But for what you would do on your own, it's almost impossible, honestly. Try it once if you don't believe it.
And next slide. Okay, we already talked about these issues. You can be hit with CMPs. You're going to pay an overpayment no matter what. Criminal, there have been cases. There was a case this last June, in fact, where 3 individuals, 3 of the cases that they cited in that June takedown involved the employment of excluded individuals. Now, typically, I will tell you the criminal cases that come up, many times it's, a doc is excluded or some other provider is excluded, and they will actually continue to work and see Medicare patients, and they'll talk some hapless other doc into letting them use their number to bill. That's how it ends up being a criminal case, because they actually took affirmative steps to circumvent the exclusion. Okay, so, exclusions are not just overpayments. They can be much, much, much worse. Next slide. You've already covered this issue. We're not going to spend any more time on this. Next slide. Okay, 2 issues. All right. So if you do find somebody that is excluded, there are a lot of different questions you have to ask yourself, and these are a list of those questions. But the only way to fix it is to do a self-disclosure. And the problem is this. Let's say that you find someone who's excluded, and you don't want to do a self-disclosure, but you want to fire the person because they can't stay, right? Well, if you think that the government's not going to find out, they will eventually. There are too many ways they can find out that the person worked there. And now, if you knew about it, okay, and you didn't do a self-disclosure under the overpayment rule that everyone on this phone call should know about, if you know about an overpayment and you have not reported it and repaid it within 60 days, plus, of course, the additional time period under the Federal Register, but if you haven't done that, that overpayment then, like Jesus turning water into wine, goes from being an overpayment to a violation of the False Claims Act, okay? So that's why it's important to screen, and then if you have a problem, just fess up, pay your lumps and move on. Next slide.
At risk of being trite, this is the classic, an ounce of prevention is worth 2 pounds of cure, whatever that saying, however that saying goes, is you just, make sure when you hire someone that you ask them and that you screen them and, you keep them out from the beginning. Because once it is a pain in the what, if once you find somebody, so keep them off in the first place is the best solution.
Now, one question that comes up a lot, Paul, is, are there any exceptions? I know this person is excluded, but he is so essential to the care that we provide, or he's so essential to the patients in this area. Yes, there are 4 basic exclusions, 4 narrow exclusions. And I will tell you that, in 30 years, I have gotten 2 of these approved in 30 years. My experience is, or Paul will tell you, our experience is that probably 1 a year is approved by OIG. And in both the cases I had, they involved individuals who were their skill set was so unique that it was actually going to really hurt Medicare beneficiaries if they couldn't have access to that person. Now, home health and hospice, it's highly unlikely you're going to be able to show that type of need. So it's I'm not saying it's impossible, but these exceptions are really hard to fit within.
I recently looked at the OIG website was looking at it, and I think I noticed that there were currently 5 limited waivers that were active at this moment.
Well, 2 of them are people that
throughout the
worked
entire
on.
country.
Yeah, well, 2 are people that we worked on.
So that's about it. I mean, like literally, I think there were 5. So they, as you say, Robert, they're extremely rare and extremely narrow, and extremely unlikely to be obtained.
Yeah. Next slide. All right. Well, the problems. Oh, this is one problem that comes up a lot. Many times, someone will come to you, folks out there, home health and hospice. They'll come to you, and you may even ask them in your application process, and you should have something in the process where you ask them specifically, have you ever been excluded? Are you currently excluded? 2 separate questions. Because let's say that you have someone who was convicted of a felony, a drug crime, had nothing to do with patient care, but it was a drug crime, and it was 10 years ago, okay? And they were excluded for 5 years. It wouldn't be unreasonable for that person to think that their time is up and that they are no longer excluded and they can work for you. They got their license back. Why can't they work for you? It's not a problem. The problem is it is not automatic. Just because your time is up does not mean you're off the list. You have to affirmatively go in and ask to be taken off the list. And before they take you off the list, one of the first things they're going to do is send you an application to do so. And it's going to say, okay, well, you were excluded 10 years ago. Where have you worked for the last 10 years? Okay, so remember I was talking earlier about how you may fire someone and think no one will ever find out about it. If that person ever tries to get off the list, they're going to list you as one of their employers, and OIG is going to be sending you a letter, and now they're going to be upset and they're going to be seeking penalties.
It's counterintuitive to the way we think, right? If someone gets a 5-year prison sentence, after 5 years, if they don't get out from good time, when 5 years is up, it's over. That's the way we think about these things. It's only natural to think that way, but that's not the case with an exclusion. And that's really, and so when that 5 years for a mandatory or 3 years for a permissive exclusion is up, well, that just means they can reapply and they can try and get off the list. Now, you would think that once the 3 years comes up, they're no longer excluded, but they can't, but they're not necessarily, they'd have to re-ask to get, back into the program. No, that's a separate question. That's a CMS question, whether they can get back in the program, or a Medicare Advantage question. To get off the list, you have to actually ask to be reinstated. And you're not necessarily, and just because you're reinstated, by the way, and you know this, Robert, as I do, just because you're reinstated by the OIG doesn't mean that you now get your billing number back at Medicare. You can still, they could still keep you out of the program, as we have seen on a number of occasions. But
that's right.
The problem
very complicated.
It has.
Next slide. All right. Now we've talked about exclusions, okay, and we'll wrap back around to exclusions at the very end. Now let's talk about this different animal called a preclusion, okay? And part of this kind of goes to this whole idea. I don't know if y'all have seen this or not. The CMS has made it very clear they really want out of healthcare in the sense that they don't want really to be managing Medicare traditional in the future. They just don't. And their plan, which they have publicly announced, is to have everybody moved over. I don't think it's going to happen. I hope it's not going to happen as someone who's on Medicare. But they want to move everybody over to Medicare Advantage by 2030. Now, in anticipation of that, I believe, as part of this, y'all will recall they used to handle the credentialing and the application process for people that were signing up for Advantage. They no longer do that. They passed all that over to the plans themselves. Okay, their responsibility. They've already shut the door on that. All right. Well, as part of that, though, they said, well, you know what? We need to have some type of list so that the plans know who we think is a bad actor that shouldn't be given access to participation in the plan, because ultimately the government funds the Advantage programs. Next slide. And that list of bad actors is called the Preclusion List. Okay? It only affects Part C and Part D. That's it. The problem is, if someone is on the preclusion list, you're not going to know it. Only that individual is going to know it, and the plans will know it. So it makes it really tough.
Yeah, it's their way. It's their way, basically, it's CMS's way of saying, well, we would not let them into Medicare traditional, and so we think you shouldn't let them into the plans. But it just doesn't make sense. I mean, if they're going to give the program that responsibility to the plans, then give it to them or not. But there it is. You don't know, and I still don't know what kind of penalty there is for you to hire a precluded individual, because that precluded there's no list for them to check, and the precluded individual may not even know that they're on that list because they may have moved from where the mail went or whatever. But that said, it's there.
It is there. There are statutory provisions regulatory provisions, I should say, for the assessment of penalties. But I will say that since this was first passed, okay, no one has ever, to my knowledge, been assessed penalties.
I'm not sure how would they assess them.
I have no idea.
Right.
Next slide.
And I guess they don't either.
So this whole list, this preclusion list, this really is a bad actor list. And there are a couple of ways that people can find themselves on the preclusion list. Next slide. The first way is it's revocation based. And as many of you may know, it wasn't that long ago to where if a provider was revoked, if their billing privileges were revoked, they were only revoked for 3 years, which is still a long time. Not for your company to go out of business, but it's still 3 years. Now that has been expanded to 10 years, and the bases, the types of reasons you can be revoked, has gone from like 6 reasons to 16 reasons. So really, I think it's up to 24. But if an individual or our provider has had their billing privileges revoked, that is the number one way to find yourself on the preclusion list. Next slide.
The offensive part about the whole list, and just so that is that and the difference between the OIG, like I said, well over 90%, over 95% of the people on that are on there based on at least some underlying action, a licensing action, a conviction of some sort, and so there's at least something there, Whereas you can have revocations can be based on so many things, and billing practices, this and that it's the people on that, it's not necessarily based on anything tangible. And that's what's really kind of the unfairness of it, which is probably why there's no penalties for it. But that's the difference. For instance, that you get revoked for failing to change location. Well, that's really a reason to keep so that you can't become a participating provider in Medicare.
That's a big reason for home health. We've represented over the years. We've represented, I don't know, maybe a dozen home health and hospice agencies who moved offices, and the government claims they didn't tell CMS that they didn't tell the MAC and CMS and the state, frankly, that they were moving. And based on that alone, when the UPIC showed up to do a periodic audit and found out they were doing there, they don't call you or anything. They immediately revoke you.
I will say one thing about this list, and I noticed, and I've looked at a bunch of cases recently, and the failure to report a final adverse legal action. An adverse legal action is a really broad definition of almost anything bad that's ever happened, okay? And it may have absolutely no impact on your ability to continue working or providing services, but they will use that. They will use that as a basis for revocation in a heartbeat, by the way. And so a misdemeanor for you took a piece of, whatever, you took something from a store by mistake and you just pled guilty to this misdemeanor and you didn't report it. The failure to report that can be used. And so beware of that. Mm-hmm. I've seen it.
Yeah, so this is a list of since we talked about the first category, this is a list of revocation actions that pop up. Next slide. The second action is behavior-based, and this one is almost, gosh, Paul, it's hard to describe because it's almost esoteric. Essentially, let's say that you were never participating in Medicare, okay? If there is something in your background, okay, or you've engaged in behavior that if you were enrolled in Medicare, they could revoke you, that's where this one comes in. They say that's enough, okay? So even though you may not have been enrolled in the past, if you were enrolled, we would have revoked you. So, there it is. We're going to put you on the preclusion list.
We denied you. We're going to deny you, and we would have revoked you.
And so therefore, we're going to add you to the preclusion list. Kind of crazy. Next slide. All right.
Sorry.
So what happens when someone's on the preclusion list? They will send notice to the individual, and the problem is that if it's a billing provider, that's great. They probably have an address in the PACO system that's accurate. They can send that out, and the person will find out, and then that person can exercise their appeal rights if they want to. But most of the people on this phone call, home health and hospice, they're not. Your nurses aren't listed in PACOs. They're not going to have an address to send it to, so they may or may not ever get the letter. Next slide. Okay. All right. So how long can you be on?
Hello,
Robert?
hello. Does anybody? Are we on? I don't even know if we're on.
I think you have to keep talking.
So how long is an individual entity on the preclusion list? Well, the length is based on if it's an exclusion action, it's based on the exclusion.
You can have a felony conviction. They can kick you out for 5 years. Okay. Well, even though they kick you out for 5 years, in the meantime, maybe you never lost your license, and now you're back in. You're off the exclusion list. But the fact is that
Robert, we're losing you. So the length is based on the felony conviction that can go back 10 years. Let's just go to another slide because I think we're... Robert? Robert, are you there? Medicare providers, can you screen? No, you can't screen for the preclusion list. It's not available. You just need to be aware of it. You need to be aware so that you can ask people who are, it's a legitimate question to ask in an employment application that you know, and to ensure whether they're on it or not. Let's go to the next slide. Since we're
all right, Paul, can you hear me? Okay, Paul, there must be a bad connection between me and you. Why don't you take the rest? Just very quick. Can you hear me, Paul?
Yes.
Okay, all right. So the difference between the two, the OIG, okay, they have mandatory and permissive exclusions. The CMS Preclusion List is.
I'm going to carry this home, Robert, because we can't hear you again. So and these slides, this series of slides that Robert's put together are really pretty good. So, the OIG is a registry of excluded individuals and entities that have been excluded, whereas the preclusion list is, they're not going to, if you're on the exclusion list, you're considered to be on the preclusion list, but they're not going to add your name. It's going to be the list of people that CMS thinks shouldn't be part of Part C, shouldn't be allowed to provide services at all to anybody, which would include they're not going to allow them into Part A or B, and they shouldn't be in Part C or D. Next slide. The purpose essentially is to fill in the gap. I suppose it's them saying that we really don't trust the Part C and D payers to catch these people because maybe their vetting process isn't as good as ours. That would be why the preclusion list is just restricted to that. Whereas the exclusion list is anybody that the OIG has, pursuant to its regulations, determined they shouldn't provide services for federal health care programs. Next. So as access, the OIG, it's published every month, or it's updated every month. Everybody has access to it. Part C and D, only Medicare payers have access to it. Next. The size of the database, it's about slightly over 80,000 in the OIG exclusion list currently, and there's maybe 4,500 or 3,600 on the CMS preclusion list. But it's growing, and it's growing pretty fast. It's growing about at the same pace as the OIG's list currently. Well, not quite that fast, but it's growing. Next. The potential penalties. So we know the penalties. We've been talking about them all throughout this process for the exclusion list. For Part C and D, there's a provision for penalties, but I'm not sure. I don't think the penalties could be imposed for you until such time as you became aware of someone on the C or D, on the exclusion list, on the preclusion list, and then they went through the process. I think it's more important that, frankly, if they're on the preclusion list, to make sure that they, find out what that's about. But there is, as Robert says, there is a provision for it, but I haven't seen any cases that have gone through it. I think the penalty is having someone on that list who may ultimately end up on the exclusion list for some reason or another. Next. Okay, final remarks. Screening. Don't think of screening as check the box. Look, I've been in healthcare. Like I said, I was in AUSA in New Orleans in the 90s and in the early 2000s. It's not, it's not a check the box thing. It's keeping people who have been adjudicated to be bad actors. They may not be bad people. They may be fine, and they may be really good, and you may really like them. But someone it's a determination that you can't fight. So there's the risk. The risks are too high, and that frankly, you can't screen everybody individually. But if these people are on it, you've got to assume that there's a reason, and you don't want to run those risks. The liabilities are too great. OIG and Medicaid agencies are looking for violators. They do that. So I think that's it. Let me see the last. Is there another slide? Look at that. I didn't even realize that. So we're apparently, offering 2 months free now. Just call the number and say HCLA. But look, use us, use somebody else. But please screen. Make sure that your employees, people you're doing business with, and the people that you're hiring aren't on those exclusion lists. It's for your own benefit, not just to check the box. You don't want them there. So I think that's it. Thanks for listening to me. There's my number. My email address, I think, is on the first page. You can contact me. You can also contact me through Liles Parker if you want to talk to me, or you know how to get in touch with Robert as well. Thanks, everybody. Have a great Thanksgiving. Eat lots of turkey, and unless you're a vegetarian, and then eat less, and then eat lots of stuffing or dressing. Have a great Thanksgiving. Bye, everybody.